facing the police every single day.
Say hi, Andy. I'm recording you.
Alright, you get the whole thing, right?
I got you.
Ocean City cops are not people.
Yes, they are. You know what's really criminal?
What's that?
Those knee-high socks.
I know, but that's what the brown shirts wore.
Hey, Sheriff County, this is Sheri County Cop Watch, and there's some interesting news that we found in the, this is a actual good thing about City of Punta Gorda. They actually get a bill from their lawyer, and of course the lawyer's got to list out everything that he's charging him for, so we get to see what's going on. And here's the latest dump that we just found. So, on the 18th, I think, of February, I've been for months protesting with projectors because that's not under their new illegal sign law banning free speech. And all of a sudden, since the snowbirds show up in force like we've never ever seen before here in Punta Gorda, they all of a sudden started giving me a ticket for the green laser projector. And then so I redacted the words, and then they gave me another ticket for having an animated object or some crap. So this has been very bizarre. So that, like I said, was on the 18th. There were some other channels that posted a video for redress, you know, to let the city government know and the police know that this is completely illegal what they're doing. Free speech is free speech. It's the First Amendment. If you don't fucking know that, what the fuck did you take an oath to? So here it is right here. Like I said, it happened on the 18th. And on the 23rd, right here, legal research regarding the 6th Circuit Federal Circuit Court appeal decision regarding freedom of speech. That case is brand fucking new, only 1 month old. A guy was wearing fuck the police shirt. They illegally arrested him in front of everybody. And this guy fought it with the civil rights case, and he won. Stripped them of qualified immunity. The judge said in this day and age, and all the case law, you should fucking know this is free speech. This guy gets, you cops get no qualified immunity. And so that, and in fact, I sent that the day that it came out. I mean, I sent it even before my friend Massey sent it, who's involved in the civil rights case. So, but apparently, you know, they're probably going to say it's because Massey sent it, and they're probably blocking my emails, which is illegal. But so anyways, then we also looked down a little bit farther on 228. Meeting with David McCarthy, Captain Nahar, and Lisa Hannon to discuss enforcement of new sign code violations. Isn't that weird? That's when I started doing the fuck everyone protest again here, protesting the ban on free speech. And the cops keep showing up and not giving me a ticket. This is intimidation, harassment, period, for free speech. So they've done it 3 times, and every single time in their police report, it says, we were there, but then he fucking left, and we didn't have a chance to give him the ticket, which is absolute bullshit. They've given me fucking tickets after the fact so many times, it's not even funny. Go watch the video on my channel. What is it? 21 tickets in a year and a half. That I know of. It is that out of control here. It's just fucking insane. You even get a ticket for trespassing if you record public officials in a public place doing their public duty. This place is full fucking Nazi. Hitler would be proud. Mao would be proud. Putin would be proud. Kim Jong-un would be proud. I mean, just go on and on. It is just so fucked up here. So I thought I would let you guys know. They know that shit's coming. I am going to, yeah. And I found another civil rights lawyer that wants this case really fucking bad. He wants to say, fuck the state court, go straight to federal. State court's a fucking joke, which it is. Because one of the civil rights cases is in state court, and it's a fucking joke, just dragging their feet. It's disgusting. So, yeah, that is what's going on. How the fucking city attorney didn't know they're going to get fried in this, I have no idea. He was using case law from the Supreme Court for the FCC, which is radio and TV, and I'm not a fucking radio and TV, so And then that's what the city council and the cops are going to say. We were listening to the lawyer. He would never lie to us. You guys are idiots. You knew he was wrong. You just fucking hate freedom and free speech. So do the redress thing, man. Call the Punta Gorda police and the Punta Gorda City Council and tell them they are complete fucking idiots. Also, too, you can tell her she's an idiot, too. This is Cheryl Peters. She owns Shorty's Bar in Punta Gorda. She assaulted me. As you see, she also had a full-size wooden oar for a boat that she said if the cops didn't show up, she would have beat the shit out of me for that. She did break my cart, and then did it right in front of the cops. Cops wouldn't do shit. And then soon after that, she fucking called 911 and said I stabbed her with a knife. This is completely out of control, people. Do your redress thing and tell them what the fuck is going on.
In 2016 in Ohio, police pulled a guy out of a crowd because he was wearing a t-shirt that said F the police. They basically taunted him and eventually arrested him. Subsequently, a civil rights lawsuit was filed. It wound its way through the federal court system, eventually ending up at the Sixth Circuit, the federal appellate court, after the plaintiff had lost. I believe qualified immunity had been granted to the police officers. So just recently now, and the case was argued in February of last year, but just recently, I think it was February 8th, the Sixth Circuit issued a published opinion in which they completely denied, of course, if you're denied qualified immunity, it doesn't matter if it's complete or not complete, you're denied qualified immunity. So that's what happened. The court basically said, look, why do we have to keep telling you police officers, as we've done repeatedly, that you can't arrest people because they use profane language? And this has happened over and over again. And I just recently posted about a case here in West Virginia where my client was arrested in his own yard for using profane language in his interactions with law enforcement. This is happening all over the country. I put the decision or the opinion from the Sixth Circuit up on the website at thecivilrightslawyer.com. It's not a long read. I would highly suggest and recommend that you read it. But let's see. Let me just go on a couple of parts of the opinion that I thought were important. First of all, again, like I said, the court emphasized, to put it lightly, that there is no, the fighting words exception to the First Amendment is very narrow, and police cannot use that. Profanity alone is insufficient to establish criminal behavior. There's a ton of case law on that out there. The court held that both the Supreme Court and the Sixth Circuit have made clear that, quote, police officers are expected to exercise greater restraint in their response than the average citizen. So like I pointed out in our West Virginia case, there has to be some third party there to hear this profane language and be sensitive to it and actually complain to fall under the West Virginia statute. And isn't it funny how I pointed out in that case that these police officers who signed up for this job are always just so sensitive. They have just such delicate ears and they're offended so easily. And you know what? That's just a joke. It's not that they care about hearing profane language. It's not that they care about some innocent person hearing profane language. What is it about? Well, it's about either, number one, respecting their authority as they perceive their authority to be, or number two, it's just a pretext for detaining and or arresting somebody and or searching somebody who's already on their radar for some reason. And both of those are improper. And this has been happening all over the country, and this is, you've probably seen umpteen YouTube videos of the police confronting people, arresting people, whatever, as a result of, let's say, profane language, whether it's a t-shirt, as in this case, or words coming out of their mouth. So I've got a lot of the case law up on the website, but importantly, the court denied qualified immunity for these officers, finding that the case law from the Supreme Court through the federal circuits was full of similar examples of illegal arrests where police officers were found to have violated constitutional rights by making similar arrests as these, including out of Ohio where this incident occurred. As the U.S. Supreme Court has held, quote, the freedom of individuals to verbally oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state, a conclusion that finds a familiar echo in the common law. So not only did the Sixth Circuit find that these police officers had committed a false arrest in violation of the Fourth Amendment by taking this guy into custody without probable cause, but they also likely committed the civil rights violation of First Amendment retaliation. So the basic three elements of First Amendment retaliation are that, number one, that the person engaged in constitutionally protected speech. Now, the court held in this case that the defendants did not even contest that the plaintiff's shirt was constitutionally protected speech, nor could they. His F the Police t-shirt was clearly protected speech according to the court. They said it's well established that absent a more particularized and compelling reason for its actions, a state may not, consistently with the First and 14th Amendments, make the simple public display of a four-letter expletive a criminal offense. Secondly, First Amendment retaliation requires that the person suffer an adverse action likely to chill a person of ordinary firmness from continuing to engage in that protected speech. The court held that here, the police officers removed the plaintiff from a public event under armed escort. That act was neither inconsequential as a matter of law, nor was it a petty slight or minor annoyance, and therefore satisfied that element. So lastly, a plaintiff has to prove, and again, this is a civil lawsuit, that the protected speech was a substantial or motivating factor in the decision to take the adverse action. And the court held that while the defendants argue, while they commit perjury, and their lawyers lie to the court, while the defendants argue that they removed the plaintiff from the fairgrounds because he was filming people, the plaintiff alleges that Blair, one of the officers, walked up to him, flanked by the other defendants/officers, and yelled, quote, "Where's this shirt? I want to see this shirt." As the officers surrounded the plaintiff and escorted him from the building, one of the officers said to the plaintiff, quote, "You've been given an order to vacate the property, so you're leaving." While walking the plaintiff through the fairgrounds, they repeatedly questioned whether they had taken, or the plaintiff questioned whether they had taken an oath to uphold the Constitution. One of the officers said they were escorting him to the front gate, and while en route to the jail, one officer said to the plaintiff, quote, "How's that work? You got a shirt that said F the police, but you want us to uphold the Constitution." The court held, therefore, that a reasonable jury, considering those facts, could conclude that the officers were motivated to surround Wood and require him to leave in part because he wore a shirt that said F the police. And therefore, they reversed the trial court's decision to grant summary judgment to the police officers and sent it back to have a trial. And that's where it's headed now, is the plaintiff gets to finally have his day in court, have his trial. So you would think the police officers and their employers, these police agencies, the government basically, would have gotten the memo by now that profane language, expletives, whatever you want to call them, alone doesn't somehow trigger martial law. So you can take a look at this ruling, again, from February 8th from the Sixth Circuit, up on the website at thecivilrightslawyer.com.